council. There'll be a couple other councilors coming in shortly, so we'll move on with the hearing so we can expedite things as quickly as possible. Judge Erskine has some important matters, and it's important that she has to get to also. But first of all, welcome to the Governor's Council. This is a very important part of the democratic process. I think a lot of people don't understand the importance of a hearing like this. Politicians like myself come and go. However, judges are there for a long time, and they have a huge influence on how our democratic society works. And it's, even though it's kind of behind the scenes, it's not a very high profile situation, these hearings are very important. So thank you for being here and being part of this process. I want to, first of all, introduce Councilor Viola from the 1st District, from Cape Cod, Councilor Timothy, and Councilor Mary Ellen Mann. I believe Councilor Devaney is coming in here also. Dear Councilors, I am pleased to nominate Deborah A.S. Capuano to the position of Associate Justice of the Worcester Juvenile Court. I submit this nomination with the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I am enclosing the nominee's resume for your convenience. Available sincerely, Bob Patrick. So, Todd, the meeting of the bank, welcome. Congratulations on your nomination. Please you call your first witness first.
Yes, the Honorable Judge Carol Erskine.
Good morning, Senator.
Judge, do you mind speaking
Sure.
to Deborah?
Sure.
Judge, if I can hold you up for 1 second also. Deborah, I'm sorry for trying to move this along. I know the judge is important business, but would you first introduce your family and anybody that you have here?
Yes, I'd like to introduce my family. My husband, Joeu DeboraCapuano, my sister, Denise Pappas, my sister, Doreen Pappas, my brother-in-law, Doreen Quatella, my brother-in-law, Anthony Quatella, and my very dear friend, Attorney Laurie Ray.
All right, thank you. Judge,
Right,
Judge Erskine, thank you for being here.
Thank you, Councilor Foley, and Councilors, thank you so much for the opportunity to testify once again. I've known Attorney Joe Capuano probably for the better part of 15 years. One of the many things we had in common is the fact that we both became lawyers after having other careers. And while my career was in the health field, Attorney Capuano's career was as a teacher. She taught in the Worcester Public Schools, which is the district where most of our cases come from, and has a tremendous background in terms of her understanding of educational issues and special education issues. That former career as a teacher brings a very unique perspective and expertise to the bench, which is something that she will absolutely utilize every single day in the courtroom. During her career as an attorney, she has demonstrated an unyielding commitment to the children and families who come before our court. She has an amazing rapport with kids facing criminal charges or with teenagers standing before the court on Chin's petition. Her strong skills as a trial attorney have been demonstrated time and time again in jury trials and in bench trials. She's appeared in front of me many times. I've had the opportunity to see her as a trial attorney in front of juries and to hear bench trials on every type of criminal matter possible, from shoplifting to rape cases. She has an amazing understanding of evidence, but most importantly, she has the compassion and the temperament to deal with the many children and families in crisis who come before our court on a daily basis. Last year, I and my 3 colleagues heard 6,398 new cases in the Worcester County Juvenile Court. Case statistics over the last 8 years show that Worcester County was either the busiest or second busiest court in the Commonwealth, despite functioning with at least 2 judges less than are sitting in Suffolk or Hampden counties, which are the other 2 busiest courts. So we not only are in desperate need of an additional judge in order to be able to cover the huge caseload that comes before us, it really needs to be a process Attorney Capuano's caliber, someone who can step into the courtroom, understand every case type that comes before the juvenile court, and in fact, she has handled all of these case types as a lawyer. Later today, I will hear a request to terminate life support for a 7-year-old child who was believed to be brain dead. In the last few weeks, our court has seen cases involving incest, rape of children as young as 3 years of age, brutal physical abuse, girls 12, 13, 14 running away, being pulled into prostitution and gangs. We've seen pregnant teens as young as 13 over the past few months, severely mentally ill children in desperate need of long-term treatment in mental health facilities. We've had gang-associated home invasions and countless families looking for assistance to deal with drug-involved children. These are the cases that we hear every day. These are the cases, if this nomination is confirmed, that Attorney Capuano will also hear every day. This is the type of person that we desperately look for in the juvenile court, someone who has committed her life to the children and families of our court, someone who understands the community of Worcester and Worcester County, and someone who understands that these families are in crisis and they are looking to the court for help. She understands, as I do, that it is one of life's greatest privileges to be able to serve the public in one of the most unique and important courts of the Commonwealth. And I'm pleased to be here to testify on her behalf, and I urge you to confirm her nomination.
Thank you, Judge.
Thanks.
Any questions? Any comments?
I'd like to thank you very much for your very sincere testimony. Obviously, Worcester, Fall River, I live in Fall River, Bedford, I represent all of the urban communities and every community.
Incredibly busy court there as well.
These tragic issues having to do with juveniles. Where do you find the optimism, and what do you see as the optimism, and what do you know that the court can bring? And how do you find that every day?
It's a good question, and sometimes it's hard to find the happy side of the juvenile court. I can tell you that last week I was out at lunch and I ran into a young man who is now 21 years old. He was a man, he was there testifying in the murder trial that had happened a few years back and had finally come to trial. He was a witness. He was a young man that I committed to the Department of Youth Services after a frustrating attempt to keep him on probation to get him to comply. He was getting gang involved. He had become involved with a very rough crowd. He was becoming drug involved. I ran into him in a restaurant on the day of his testimony, and he said, "Judge, I just want to tell you that I never had a chance to say this to you, but I want to thank you for committing me to the custody of the Department of Youth Services. You committed me when I was 17 years old and still under the court's jurisdiction." And I went into DYS. I was put through a program and made a lot of changes in my life. And when I was released at 18, I had my diploma. I'm in college. I'm in my 3rd year of nursing school, and I'm getting accepted into a master's degree program to become an anesthetist. And I just want to tell you that that decision you made to commit me to the custody of the Department of Youth Services was, life-changing for me. So he's not the only story that you get like that. It's difficult to say to a parent that we're going to commit your child to the custody of the Department of Youth Services, or it's difficult to terminate parental rights and say we're terminating all your legal rights to this child. But the day you walk into court and you see this family on National Adoption Day or on last Thursday as I did an adoption for an 18-month-old little girl, then you understand that, in the end, a lot of good comes out of what we do. When I had recently a young lady who was pregnant, victimized and became pregnant as a result of a rape. But making a decision, with the court's involvement in discussions, making a decision to keep the child and getting her into a teen parenting program and working with resources around us. So put a program together. We put an amazing program together called the Teen Live Program, which has caught the attention of people in Washington, D.C. It received a public health grant because of the unique collaboration between the hospital and the court to bring children into the hospital and to have surgeons and other people who all give up their time to talk to them, and have people who have been in car crashes talk to them, to have them go to the emergency room and go through a long trauma, to have them go to the ambulance bay. It's an incredible one-day program that has a recidivism rate of less than 2% over the 3.5 years we've run it, and over 300 children we put in. So there's so much to be positive about.
These are drivers, young people.
These are all teenagers who are basically first-time offenders who got into a car and drove without a license or were driving drunk, and oftentimes they crashed and someone got injured. And the program has had just an amazing success rate of less than 2% recidivism rate. I go on Saturday mornings and I talk to these kids, and the chief of pediatric surgery is there, and the chief of pediatric emergency medicine is there, probation officers are there, all to keep these kids alive when they go back into the community, rather than treat it purely as a criminal case and locking kids up and saying, I'm keeping you off the street because you're getting into a car and driving. Say, this is what we're going to do to keep them off the streets and to keep them safe, but not necessarily to give them a criminal record that's going to follow them when we can resolve it in another way.
Did you share that program with other chiefs, chiefs throughout, like, for example, or other ways where we get together?
We've had calls from other judges. We've had calls from other judges. We had a couple of calls from Springfield where kids had serious driving offenses, and we have allowed them in. We have national companies like Allstate that are now asking to let it be considered a 24D program, which is a drunk driving program for adults, but for kids. There's a tremendous amount of interest. And we've done that. We have the STAR program for girls that are being abused in relationships. We have just many wonderful programs to work with these kids. So there's so much positive coming out of it. We're looking every day at our philosophy is we need to look and see who's coming in the door to our court and then address those. And that's not to say we don't adjudicate kids, that kids do not serve time in the Department of Youth Services, that that's the appropriate sanction. Those things do happen, but I think it's our obligation as a juvenile court, in essence, to look at who's coming in the door, why families are in crisis, and then to see what programs we can put into place to address those while kids are on probation. So I think it's working.
Thank you very much. Thank you, kind of passionate judge you want to.
She'll be the same, I guarantee it, for many years. Any other?
I have a question.
Hi, nice to see you again.
Nice to see you too. Thanks, Council Foley. I just want to know what the breakdown is. You may have said this, but if you could give me some, average work week or work month, because I'm not sure how you get it. Or in a year. What's the number one grouping of cases that you have? What's the bulk of your time committed to as a juvenile court judge?
Right. The bulk of our time in terms of case numbers is delinquency cases. We have not only delinquency cases coming into the magistrate that might never make it into the courtroom, but the bulk of our cases, well over 3,000 last year were delinquency cases.
And do you include chins in that?
No.
Okay.
Chins cases being separate. Right.
These are status offenders or some sort of...
Right. Status offenders, which are, of course, the truants and the runaways,
right.
Habitual offenders, as you know, and then the delinquents.
Don't know too much about juveniles.
Right. Okay. The delinquency cases are kids that are charged with crimes, like any other kid.
Okay.
They're either charged as delinquents, or if they are indicted by a grand jury, they're charged as youthful offenders, and they're still before the juvenile court, but they can be sentenced by a judge to either a juvenile penalty or an adult penalty, including state prison or to both. With sentence.
Okay. And could you assign a percentage to those? You said the bulk. Is it 80%? Is it 20%? Is it 50%?
Yeah, I would say it's probably 50 to 60% of our cases are delinquency criminal matters.
Okay.
And then a huge percentage of them are chins cases.
The next group.
The next group,
okay.
which are status offenses, meaning runaways, truancies, habitual offenders, stubborn child petition. huge number of those cases as well, although without the statistics in front of me, I would say that probably comprises another 25% of the cases, maybe more.
Okay, so now we're talking 75 to 85%
Correct.
of the cases. What's left?
What's left are the child abuse cases, care and protection cases. So those are cases where the department is petitioning to terminate parental, to remove custody from a parent and or terminate parental rights. Those cases last year in Worcester County were between 500 and 600 new child abuse cases in the county, 300 in the Worcester court alone, which requires Worcester and the contiguous towns of Holden, Paxton, Middletown. About 300 new child abuse cases, which actually is unprecedented in terms of new filings. Those we're hearing on top of the ones that have already been filed and are in the trial process. And so at any given time, we have hundreds of care and protection petitions going, but new filings this year alone, by May, about the end of May, we had about 135 new child abuse cases filed in the first, 5 months of the year. It's really a high number, given what we've seen in the past year.
Okay, so now for delinquency and chins, those are juvenile rules of court. And then the care and protection are the regular mass rules of procedure.
Yes, there are standing rules regarding the procedure for care and protection cases that have some variation on the rules of civil procedure with respect to discovery and the requirements of the judge for certain things like interrogatories and things of that nature. And of course, there's a huge body of case law outlining the evidentiary exceptions to the hearsay rule that don't exist with other cases, separate, of course, of the delinquency cases. And then, the delinquency, the chins cases, they're status offenses, so they're not really criminal cases, but there's also a right to a trial and to find beyond reasonable doubt as well. And then there are the youthful offender cases go by the Superior Court rules. It has to be a jury of 12 because they're subject to sentencing to state prison. So
jury trials as well?
Oh, yeah. I'm talking about jury trials, and if it's a delinquency, it's like the district court, it's a jury of 6. But if it's a youthful offender, we use the Superior Court rules, the Superior Court jury instruction, because they are felonies where there was a threat of serious bodily harm, where there was bodily harm. So those things would be like some of the rape cases, more specifically home invasions, firebombing, things of that nature might be more subject to indictment as youthful offenders. Then they're rearranged in the juvenile court, but they're treated as adults, in essence, and subject to more serious penalties.
I'm much smarter now. Thank you very much, Judge.
Judge, thank you. This is very helpful when someone comes in here, by the way, and answers the questions.
Thanks. I very much appreciate the opportunity to testify on it.
Thank you very much.
Judge, I want to thank you for your service.
Thanks.
After listening to everything you said, and a little bit of knowledge about myself, all the time that you put into your dedication and passion for it, we're very lucky to have you all this to do well.
Well, I appreciate it. It's really an honor and privilege to be here.
I don't have to listen to it. I don't know if Deb wants to reconsider. You want to continue with this?
She'll do an amazing job. Thank you.
Thanks, Judge.
Thank you, Judge.
Anybody else?
Yes, Michelle Boyd.
Welcome, Chief. Chief of Westboro, Council of the Maine District.
Good afternoon, as the Colonel said, I am Al Boyd. I've been a police officer in the town of Westboro for 35 years. I've been the chief for the last 7 years. I've known Attorney DeboraCapuanoNominationHearing290 for approximately 16 years. She was an attorney, defense attorney at the Westboro District Court when I was a patrolman and up through the ranks. I was always impressed with the knowledge that Attorney DeboraCapuanoNominationHearing290 showed during her courtroom trials. Her demeanor was second to none. She always 100% represented the client. She did a tremendous job, much to my dismay sometimes. But she was always prepared in the courtroom. She had herself prepared for everything that was to take place. Through promotions in the department for myself, I don't have as much to do with the court anymore, but I do hear from my officers, and they continue to say what a great job she does. very, very honored that I could appear here before you this afternoon to appear on Attorney Capuano's behalf. If she does become a judge, she will be an awesome judge, and I'm looking forward to it, and I would like to thank you.
Thank you very much. Questions?
Thank you very much.
Chief, thank you very much. Next witness.
Kelly Orlando.
Good afternoon, everybody. Thank you for letting me come here. Doesn't happen very often. My name is Kelly Orlando, and I'm appearing today on behalf of DeboraCapuano. I've been her legal assistant for the last 11 years. We first met back in 1993 when I was a secretary for Attorney Robert Reynolds, and Deborah something from him at that time. I started working for her in April of 1998. And she allowed me to join her in the design and the layout of the offices we now occupy. And I believe she'd be a wonderful asset to the Commonwealth in the capacity of Associate Justice for the Juvenile Court. Over the past years that we spent together, I've witnessed the way she treats her many clients, both with compassion and understanding. She and I work side by side. She's allowed me to grow personally and professionally in my capacity from a secretary to a legal assistant. She's a good listener and considers all sides of the case. She's been very thoughtful and sympathetic when it comes to her clients. And she's always attempted to keep her clients well informed of how their cases are progressing. In my opinion, based on what I've observed in the last 11 years, there's no better person to have to be the next justice of the juvenile court. Thank you for letting me speak.
Thank you.
Thank you very much.
Any questions?
No, I always welcome the assistance of a nominee because you see her day-to-day basis and good time to bad time, so your testimony means a lot. Thank you.
I'm sorry, no blessing, but I appreciate it. She should be, thank you.
Well, you got through that, Kelsey.
Yes.
Attorney DeboraCapuano.
Good afternoon. My name is DeboraCapuano, and I'm here to support the business nomination. I have been an attorney for the past 10 years, and I first met Deborah when I was a freshman in high school. She was actually my high school English teacher. And after graduating high school, we went our separate ways, and I never thought that our paths would cross again. But they did, and they did actually in the juvenile court. That's when I first saw her, and it was a pleasant surprise when I walked in there and Deborah was there practicing law. Deborah was my teacher, and when I started practicing law, she became actually my colleague. And it was extremely refreshing to be practicing with her because she did not treat me as a student anymore. She was really treating me as a colleague, as someone on the same level that she was. She became a mentor for me, practicing law. She was one of the few attorneys that I would seek help from, I would seek advice from. And even though she was a mentor, she was also an adversary at the same time because we did handle cases together where she was an adversary. She stood on one side and I stood on the other side, and our clients had opposite positions, and we had to be adversary in those situations. I have been a witness to Debbie's double advocacy for many, many years, and I've seen her, whether her client is a child who has mental health issues, who is before the court on delinquency charges. I have seen her representing parents who are having difficult times and are fighting for their children's rights, to have their children back. I've seen her representing adults in the district court, where she's handling cases of either a drug addict or someone who's charged with operating under the influence of liquor, and she's trying to help them out. These are wonderful qualities for a lawyer, and they are even an asset for a judge because she understands these people. What's required to become a judge is certainly much more than knowing the law. It requires a full understanding of all of the individual cases before you. It requires a balance of protecting people's rights against the safety of the public. requires a balance of being a stern judge, but also being compassionate to those people before you. I believe, and actually I know, that Debbie has those qualities, and she will be an exceptional judge. Debbie taught me in high school to listen to other people, to respect their opinions, and to conduct yourself in the highest manner. And as I've witnessed her as a lawyer, she has followed her own advice, and she has conducted herself in that way. I'm asking you to confirm her as a judge in juvenile court. Thank you.
Thank you very much. Thank you very much.
Okay, is there anybody here present that would like to speak in opposition to the nomination of Joeu DeboraCapuano? Okay, hearing none, Deb, would you please use the show statement?
Yes, thank you. Good afternoon, ladies and gentlemen of the Governor's Council. It is an honor and a privilege to appear before you today, and I want to thank you for this opportunity. I would like to thank Governor DeboraCapuano for his nomination for this position as Associate Justice of the Worcester Juvenile Court. His confidence in my ability is encouraging and greatly appreciated. I would like to extend my thanks for the confidence of the Judicial Nominating Commission. A special thank you to my husband, John, for his love, his support, and encouragement. He is my best friend and greatest support. Thank you to my witnesses, the Honorable Carol Erskine, First Justice for Worcester Juvenile Court, Chief Alan Gordon, Chief of Police for the Town of Westboro, Kelly Orlando, who has been my assistant for 11 years, and Attorney Navarro Rahab, my former high school student and now my colleague. Thank you for your support and for taking the time out of your busy schedule to testify today on my behalf. I would also like to acknowledge and thank my two sisters, Denise Pappas and Doreen Quatella, my brother-in-law, Anthony Quatella, my dearest friend, Attorney Florida Richardson, being here today to lend their support. During this process, I've had a chance to reflect upon my life and my career. I grew up in a loving, supportive family. I am one of 3 daughters. I am the oldest child. My parents did not attend college. My mother graduated from trade school and became a beautician. My father left school at the end of his junior year in high school to support his mother after his father had passed away. This was a decision that my father always regretted. He enlisted in the Army at the age of 18 years old and served his country during World War II in Europe and the Philippines. He worked as a salesman and a truck driver until I was 16 years old. He then went to work for the Commonwealth of Massachusetts and worked his way up to the position of Assistant Chief in the Division of Insurance, retired in 1992. My parents always stressed the importance of education and hard work. They sacrificed and did without in order to give us the opportunities that they did not have. But we were always held accountable. We were not spoiled. My parents expected us to study hard and to get good grades and to do the best that we could be in whatever we chose to pursue. Most of all, they expected us to make a difference in this world. Amongst other things, my parents taught me that nothing in life is insurmountable and that every experience in life is a learning experience. I thank my parents for the values that they instilled in me at a very young age. communicate effectively with my child clients, and to understand the behavioral, social, emotional issues, and school issues that they experience. I possess a passion for the juvenile court and the law, and have always been guided by the principle, the best interest of the children. The juvenile court plays a unique role in the Massachusetts court system. It has jurisdiction in 3 types of cases, including delinquency, youthful offender proceedings, child needs services proceedings, CHIN, and care and protection, termination of parental rights proceedings. The court also has ancillary jurisdiction over guardianship petitions, paternity complaints, equity petitions, and adoption petitions. As an attorney, I developed legal expertise in each and every area of the law that the juvenile court has jurisdiction over, as well as mental health and family law. My experience as a school teacher and as an attorney has enabled me to address the various issues that have arisen out of the cases that come before the juvenile court. If given the opportunity to serve as a justice, I will ensure that the children who come before the court will be provided with the necessary services to address their needs. I realize that as a justice in the juvenile court, there will be difficult decisions to be made. It takes courage, confidence, knowledge of the law, and experience to make these difficult decisions. I believe that I possess the practical life experience, common sense, and the legal expertise that is required as a judge to make these decisions. I am confident, given my legal education and experience, background as an educator, and my life experience, that if I am confirmed, I will be an asset to the court and the Commonwealth as an associate justice of the juvenile court. It would be an honor and a privilege to serve the Commonwealth and the children and families who appear before me. I thank you very much for your time, and I would be happy to answer any questions that you may have.
Thank you. Councilwoman?
Thank you. Nice to see you again. Now, did you apply to a position in the probate and family court?
No, I didn't.
Okay. Because when you left me a message on my machine, letting me know that you were available to answer questions, you actually said that you've been nominated to look to probate and family court.
I'm sorry, I was nervous.
That's all right. I was about to call. I looked up I was reading, begin doesn't make mistake. So I read the State Health News Service and it says juvenile court, and I was going to call and say, don't you know that it's probate court?
My mistake.
Okay, so you didn't apply to the probate court then? To any probate court?
No.
Okay. When did you apply for this position?
January of 2009. Actually, January 28th.
Okay. And is that the first time you've ever applied for a judgeship?
No, this is the 3rd time. I applied in 2006 for a position in the Worcester Juvenile Court, and also in 2008 for a position in the Middlesex Juvenile Court.
Because these donations that were made, one of them to Tim Murray, you applied in 2008, you applied again in 2009, it appears that the Executive Board of Bar and Donations was violated. Do you have any explanation for that?
The donation to Tim Murray was donated prior to my applying for Middlesex position.
You applied to Middlesex in what month, 2008?
I believe it was in August of 2008.
Okay. What prompted you to donate $100 to Murray? Because I went through the OTPF, which is the Office of Campaign and Political Finance website, to see whether or not you were a regular donor, and you're not. what prompted you to donate to Tim Murray before your second attempt at an exemption?
It was basically my support for the local bar. Lieutenant Governor Murray was her attorney. You see from the other donations that I've made, they're all attorneys, former attorneys, and to show my support for the local bar.
Was there a bar fundraiser?
It was, yes, it was a fundraiser. I believe it was his birthday.
Okay. Where was the fundraiser?
It's the Coral Seafood in Worcester.
I know that in the village. Okay, I think, yeah, okay, did you ever donate to the 71st Fund? 71st Fund?
No, I don't know.
Did you, oh, that's okay. Did you donate to any other PAC or anything like that? Any other, okay. So what you're saying is that you donated to Joseph Early in November of 2007 because he's a Worcester attorney?
That's correct.
And Stephen Abraham, he's actually the registrar of probate, and you donated to him because he's a Worcester attorney.
Correct.
Now, prior to the last 3 years, when's the last time you made a donation to a Worcester attorney?
I didn't donate to anyone prior to that.
Okay. So these 3 donations are the only donations you've ever made.
Right.
Okay. And you understood that this request had to do with federal donations as well?
That's correct.
Okay, you're including that in your answer.
That's right.
Okay. Did you have any conversations with anybody about any concerns that were raised about your nomination? Not today?
I haven't had any conversations with anyone.
Okay. We got that, okay.
Yes.
Okay. And when I looked you up on the website that tells how much money various people have made as lawyers for, like committees of public counsel and that sort of thing. And I did some rough calculations. Would you agree with me that you earn about $50,000 a year as a public lawyer?
Well, I'm not a public lawyer. I'm an attorney, a private attorney who accepts cases.
Right, but those
are
okay. Now I really understand that concept. So it's taxpayer money. You're appointed to represent somebody.
That's right.
Okay. And they don't pay.
Actually, in the district court, they do the judge can assess them a fee.
Okay.
Many times it's $150.
Right, that's a victim witness fee or something like that. Does that go to you?
No, it does not.
Okay. I'm just talking about money that goes to you. It all comes from the state.
We bill the state, and we're compensated at a rate of $50.
That's what I was going to ask you. Okay, so if you make about $50,000 a year, you get compensated about $50 an hour. You work about 1,000 hours a year as a taxpayer-funded attorney.
Right.
And the rest of the time, you are a private attorney.
Yes.
Okay, so that's about 20 hours a week as a public attorney. So, what did you earn last year as a private attorney?
Private attorney, I believe.
And I'm not including, $50,000. Not including that.
Not including?
Yes.
It was $100,000.
Okay. And those were all either probate, criminal, or juvenile cases?
Yes, and also I'm the regional coordinator for Worcester County, so I'm compensated also from the Committee of Public Counsel Service.
I didn't know that. Okay, so what, do you get a salary there?
No, it's an hourly. In other words, we bill for the time that we put in as liaison to the court, as mentors, offering certification training.
Is that included in the $100,000? Okay. And how much a year do you earn as a regional coordinator?
It varies. I believe it's maybe $20,000.
So the remaining $8,000, you think that that's what you earn approximately as private attorney, that would be for probate cases, criminal cases. Are there any private juvenile cases?
Yes.
Okay.
Oh, yes.
Okay. Now, of the, let's stick with the $50,000 where you're getting compensated by public funds. What's the breakdown of those cases?
Just to clarify, I believe I've made more than $50,000.
Per year, and that's the case?
Yes, working for students, yes.
Okay.
Maybe between 50 and 70, I can
Okay.
right now.
Yeah.
And you want to know the breakdown of the cases?
Yeah.
They're youthful offender cases,
Mm-hmm.
they're delinquency cases,
Mm-hmm.
they're CHIN cases,
Mm-hmm.
termination of parental rights.
Okay, so how much of your caseload in juvenile court, I understood, well, you know what, let me ask you that. I didn't understand how much of your caseload, I don't think, because you did right in here. There were percentages, but now I have, yeah, you have civil 35%, criminal 35%, probate 30%. So where are the juvenile cases in there?
The civil case, well, the civil cases,
Are all juvenile?
they would be termination of parental rights cases.
Okay.
They would be CHIN cases, status offenses.
Yes.
All
Included, that covers that, pretty much. And then the criminal, you were referring to juvenile court. You were. So you were referring to both juvenile and district. Okay. And of course, probate court, that's not juvenile court, that's divorce.
Probate court, there are times when I'm appointed by the court itself.
Right.
Regarding that wonder.
Right.
Also represent the children in child protection proceedings.
So you've represented children in parent protection proceedings in family court.
That's right.
Okay.
As well as mental health.
So this breakdown wasn't really helpful for juvenile appointees, but you know what I'm saying? I mean, I can see how that, so of your whole caseload, from soup to nuts, how much of your time is spent in juvenile court?
I'd say maybe 55 to 60%.
Okay, and the balance of it is split between family and criminal?
That's correct.
Okay.
But in the probate court, there are also, as I said, there are also cases that deal with the care and protections, that deal with the Rogers, quite similar to juvenile court.
Okay. Roger's hearing for the medication.
Yes.
So how many divorce cases do you think you do a year? Contentious divorce, contested divorce.
Contested divorces, probably maybe 10.
10 years. Now, you're not in any relationship with college, right?
No one knows.
Okay, your husband is?
No.
And how many trials, parental rights trials have you done?
I believe I've done 4 terminations of parental rights, so
Full trials.
full trial.
Have you done any appeals work?
No, I haven't.
Okay, so you're not appointed to do appeals work? Okay. And I learned today that there are jury trials in juvenile court. Have you done any jury trials?
Yes.
How many jury trials have you done?
We did 6. I've tried 2 juries of 6 and 2 juries of 12.
2 juries of 6?
No.
Okay.
1 jury of 12 was the youthful offender rape case.
Yeah.
There was, I believe it was 4 jury of 6. 5.
Okay, and the bulk of the time that you spend in juvenile court
recall that we faxed you over a report. Yeah.
Okay, when do you think it's appropriate to withdraw from a case? Let me ask you this. How many times have you withdrawn from cases in the middle of, before completion?
I've never withdrawn from, I've seldomly withdrawn from cases. For instance, the case that you and I had together, I was withdrawing at the suggestion of request of my client because she said that she was going to have a friend who was going to represent her.
So what you're saying is that the client said, asked you to withdraw from the case?
Because she couldn't afford to pay me and said that she was going to have a friend that was going to represent her.
And you, did you file a motion to withdraw on that case?
I believe that I did.
And did you notify the client of the hearing on the withdrawal?
Yes, I did.
And do you recall whether she was there?
She was not there.
And do you recall why she wasn't there?
I have no idea. She was not there.
Okay.
I know that I worked extensively on that case.
Right. Let me tell you what I remember about that day. I remember that I went out to Worcester and to meet you about that case, and you told me to be right back. We went into the courtroom and we waited for you, the client and I, in the hallway, and when you came back out, you had withdrawn from the case. So that's what I recall.
I don't recall it at all. It was very, very good. I spoke to that client at length prior to my withdrawal. And I don't recall meeting you. I'm sorry.
No, I mean, so the concern, I think, that I have is that, the client is looking to lurch on a hotly contested divorce case that has not been completed. And, as a colleague, I can tell you that my impression that day was that I had been misled to wait you out in the hallway. And then, the situation had completed itself, the withdrawal had completed itself without me or what became now my client after that had a chance to address the court. And when you came out of the courtroom, I tried to talk to you again. You basically ran off.
Again, this is troublesome. I don't recall meeting you. I recall specifically their case. I recall the amount of work that I did, including Christmas Eve, and it was a very contentious.
It was a very contentious case.
It was. I don't recall. I know that my assistant faxed you a report, and I don't recall meeting you, and I don't recall that day.
Okay, I've also gotten some feedback. I'm still trying to get some feedback from local voices. I can't say that I'm regularly in Worcester County, but I've been in Worcester County Superior Court, and I've been out there for workers' comp, and I've been out there for federal court, and I've been out there for probate and family court. So I do know a number of Worcester County attorneys. Some of the feedback that I'm not that some of the feedback that I'm getting is along the same lines of what my experience was with you. So and there was one thing that I do want you to be able to address. I wasn't there for it, but were you physically attacked in the courtroom?
No.
Okay. among lawyers?
No.
Okay.
I have no idea why anyone would say that.
Right. Okay, well, that's why I asked. You know, 'cause, people, the difficult thing is that, we do get a lot of information from a lot of sources, and for whatever reason, I try not for whatever reason. It's my practice not to, if I can't confirm anything, I don't listen to that information. If people don't want to come in and talk to themselves, I disregard it. But if I can independently confirm something, that's different. But I wanted to at least give you the opportunity to explain, if that happens, but it didn't, so that's fine. I think that's everything that I had. In that particular case that you withdrew, so I just wanted to one more time. It was your memory now that, and when I say that, if you went back and looked, you might remember things differently, and that's how things are. Just based on now. It's your memory that the client asked you to leave because, she was running out of money, and that's why you withdrew.
Absolutely. She said that she did not have, she had, the bill was in 5-digit area. I was in court constantly. She specifically told me that she no longer could afford to pay me, and subsequently filed bankruptcy and named me as a creditor, and told me that she was going to have a friend that, I believe she said she went to college with you, that you were going to represent her, and that was the reason why.
She may have had somebody else, in mind. I don't know.
I specifically mentioned you.
Yeah, I didn't go to college. I didn't go to college with her. I represented her.
She said that you were a friend, and that's why. And subsequently, she said many attorneys, and even your representation. The case is still continuing without my understanding, because I had been in court one day when an attorney, I believe it was her ex-husband, filed either a contempt or a modification, and he was there representing her. She was not there, but he was there. The husband was there with his attorney, and her attorney was there, but she was not there.
Yeah, just so that you're clear, I'm not, I represented her on that several years ago.
You went to trial.
And then I picked up where you left off and finished up her divorce for her. And so I didn't complete that situation. I don't know anything about bank theory or anything like that.
I was told by her attorney that on the financial statement, she listed me as someone who showed money too, and also you that showed you money also.
No, that's not a comment to my client. There's a big, beautiful mansion being built for heaven's sake, brick by brick, with all the Okay. Thank you very much.
Thank you again. Good meeting you.
Thank you.
Our council meeting was very thorough, and I just kept talking as I was finishing up with them. And so I would like to, first of all, talk about custody. And that all the other things that hasn't covered yet.
Excuse me, just for 1 second. I just wanted to, I am completely up to date with that comment. So that 50 minutes, I should do it money, I made a joke out of it. I actually recall, I am completely up to date with that comment. Just for clarification. I'm sorry to interrupt you. That's all. Thank you.
In private practice,
One good thing about this, Chief, is we're getting peppered by them all the time on the stand. It's great to see the attorneys going back and forth.
I love it, Colonel.
Good.
in private practice, what is the percentage of men versus women that you represent in custody cases?
Probably about 65 to 70%
Of what?
men.
How many cases have you
going to say maybe 10 to 15%.
I don't like percentages, it's how many cases, that isn't in percentages, how many cases would they be shared custody?
Maybe 4 or 5.
Shared custody, that's all. What's your philosophy?
My philosophy is that there are a lot of factors that have to be considered. First of all, if the parents are on board together in raising their child, you have 2 separate kinds of parenting styles. Also, with the child, I've always felt that a child shouldn't have to look at a calendar to see where they're sleeping tonight, if they're sleeping at mom's or they're sleeping at dad's. And if the parents live within reasonable proximity of each other, because it's one thing when children are babies, but then when they go to nursery school, and then when they go to school, to make sure that, both parents are doing the homework with the child, both parents are taking the child to school. So that's why it's been a low number of cases. If parents are, if it's an acrimonious divorce, and I feel the children are being placed in the middle of this, then so I'm just thinking, you're asking over my career, maybe 4 cases out of 25 cases.
And, but you represent men. You said you represent more men than women, right? So that you...
In many cases, men are not asking for shared custody.
That's surprising to me, not from men I hear from, than the letters and calls like that.
I have only,
In fact, most of them want full custody, but they share custody as second best, from what I'm hearing.
those that have asked for the shared custody, and remember that the only way that a judge can order shared custody is if the parties are in agreement. If they're not in agreement, a judge cannot order shared custody. So in all of those cases, the parties can come to an agreement, and they have what's called a parenting plan.
Sorry, saying that both are very good parents and the marriage just isn't working out in a divorce, what do you advocate for to encourage shared custody?
In that case, yes, shared custody I advocate, because if they're, again, on the same page, and the child is, their focal point and interest is in the child, all right? Because children suffer, they're impacted by acrimonious divorces. So if the child, if they're both, have similar parenting values, they're both committed to the child, if they're both committed to the child's education, then I advocate for that.
Would you have this policy if, say, the mother of the child in this custody wants to move, say, from Massachusetts to Oregon? I mean, do you have any kind of, process that you go through to allow it or not allow it, or?
Well, first and foremost, we don't have those kind of cases in the juvenile court. That's something that you would see in the probate court. Those are called removal cases.
Oh, well, I'm just looking at your background.
There is legal analysis. There's case laws that are done. Basically, it's the real advantage test. So as far as policy is concerned,
as a lawyer, when you've had a custody case, have you ever had...
I've only had one removal case.
So you've never had the wife wanting to make a move quite a distance from Massachusetts?
I've only had one removal case, and in that particular case, the ex-husband was in agreement. And what we did was we worked out a visitation schedule where the child would come. I believe the woman was moving to Florida. So we worked out a
looking at legislation through the years, which I have, I don't think it just says, you know, shared custody. I think that it would have sections and chapter of what would constitute shared custody, you know, what would be required. Okay, I have all these things covered that I asked. I wanted to know the percentage of delinquency and all of that, so you covered that. Can you tell me what GAL is, next friend, appointment? I'm not a lawyer, so I have no idea what that means.
Guardian ad litem.
Okay.
In many cases,
Next time, if you ever write anything, you should spell it out for lay people like me, because I know what that means instead of a GAL for gal, so
okay, guardian ad litem. All right, guardian ad litem, next friend, there are different types of guardian ad litem. Some is next friend, where we step in and into the shoes of the child, and advocate for the child. There's also investigative guardian ad litem. If there is a he said, she said situations that arises, the judge's court can't step down from the bench and do his or her own investigation. Therefore, a guardian ad litem is appointed with a specific purpose. Guardian ad litem to investigate custody. Guardian ad litem medication, things of that nature. That's what we do.
The other thing is, just to go over again, when you first applied, 2006,
That's correct.
and that's going on?
Yes.
And how far did you get?
I was about 14.
You sent that to
Yes, I was.
and then what happened?
I was not on. No.
Okay, you got a letter or something, or something?
Yes.
Okay. So then you applied next 2006?
That's correct.
Okay, and
I was interviewed by the Judicial Nominating Commission
you withdrew from this case, you notified her, you notified that client, and I'd like to know, when did that conversation take place? If she was out in the courtroom that day, outside the lobby, and she had no idea when you went by that you were dismissed, you dismissed yourself from the case.
No, that's incorrect. I notified my client when I filed my motion to withdraw. I sent her a copy of that. My motion.
What point in time? I'm not aware. Was it that day?
No, it was well in advance. It was well in advance. We have to do that, to notify our clients and then to mark it up. I'm an officer of the court. My word is my bond also. I have no recollection of it.
Did you have a letter that your assistant said, did she have a letter that she sent to that client that you could produce to us?
I guess we could go through the file.
Well, did you know the date that she put?
That, again, and I don't recall how long ago that was. That case has to be maybe 6 or 7 years ago.
Yeah, as I said, I'm not aware. I don't know how long you keep records, but
we filed motions to withdraw. The client contacted me and specifically said she did not have money to pay for my prior legal representation. I never withdraw from cases if clients owe me money. Many clients, because I feel that once I file my appearance, they can't afford to represent me, they can't afford to be crossed.
Do you do pro bono?
Well, it turns out to be pro bono after a while, but I don't believe that it's right to withdraw just because a person doesn't have money, and it's costly, especially in adversarial cases. This particular client said that she did not have any money to pay me, and that she was going to have a friend of hers, Attorney Manning, who was going to represent her, and therefore asked me to file my withdrawal. I would have to file a withdrawal because you can't have two attorneys on a case.
Is there anything else was covered that I want to ask? Council meeting had asked already. And can I ask the chair, I want to go to the chair, I know procedure, but there's an awesome responsibility to appoint the judge when it's a lifetime position, and there's no a review. I really need to ask right now through you, Council Manning, can you just verify anything more about that? Because I got a lot of to fill in the drafts, because I'm really concerned about this, and before I can vote, this has been enlightening to me today, and very important for me to know that a judge is respectful, considerate, whether it's another lawyer, whether it's just a citizen, or whether it's a client. And I'm concerned about that whole scenario about her walking by and everything else. Can you just fill in how it happened and why you were there, what was the purpose, and what happened?
I don't know if Councilor Manning had her
every court, district is a lot of general stuff, area has its own, certainly juvenile probate, not such difficult courts every day. What I specifically see in your application, which I think sets you apart and sets you above a lot of people, is that depth of educational background and dealing with youth and troubled youth and IEP and ADD and all that stuff, the mental health issues that are going on in the school. Because as you have referenced in the JNC application, you talk about that's the challenge of the court. Because today, there's zero tolerance in the schools, and so everybody takes right into the court system. And that's what's on top of the mind. I mean, I believe it's definitely the middle ground, and we have some alternative programs, we have some after-school programs, we have a lot of alternative options in our school system that key saving some of these kids. Because the horrendous lifestyle of family environment, a lot of kids there. In Berkeley High School in Fall River, where my children were at school, it's incredible to think of how these kids need to get to school every day and want to learn. And what happens, having your perspective, I think, is so important because some of the teachers forget that. They're seeing a restless kid, and they're just aggravated with them, they give up on them. And then I realize he doesn't have an advocate at home. He doesn't have a parent. She doesn't have a parent advocate. She's just a loudmouth girl. Well, she's got ADD. Nobody recognizes that. Get her the help she needs. And you see that every day with your clients. And you see Judge Earthtown sees it in the court. And so it comes with just a whole circle. If somebody doesn't help these kids, they're going to be in front of you as a judge. And I believe you will have that knowledge and background. Will you be able to save every kid? Absolutely not. Absolutely not. But it hurts me when I see these kids that my children are aware of and see. And I know as a parent advocate myself, as you have been, I've been seeing through all the records I've read, that it's not easy. It's a fight every day. And how many of these parents in these urban communities have to fight every day? They just don't. It's reality. They sound nice to say that parents care, they do. But they care only within the limitations that they're able to care. They don't know how to fight for a 5 or 4. They don't know how to fight to ask those teachers to do a little extra time, or whatever it might be. So I think that sets you so far apart as a candidate, and I really like that. I think that everything you've done in your career, just support, or it will bring you to where you need to be on the bench. That's really my big, so many questions have been answered today, and I appreciate the thoroughness of some of the questions. But I just think that is so important. And I think that the court, it sounds like the court that you would be going to is ahead of the game. I don't remember ahead of the game, but at least has brought on and advocated and created so many programs that other courts don't have. And the one thing I would say is that, I'm going back to some of my groups, and I was brought back home and saying, Judge so-and-so, you're aware of these programs, and I think that's what sets a judge apart. You can come with all this experience, and you can sit at that seat and rule the law and make some decisions. A lot of people can. Statistically, you're sitting here, but it's very statistically odd, because of the numbers of non-applicants for these positions. You only pick one person. And I think I have to bet the government pick somebody that has the right niche of experience, and it seems that you have the passion. And how would you not get tired on the bench of listening and dealing with all these troubles every day, all day? And how would you have the patience for that? I mean, if you feel you have the patience to deal with
Absolutely. As an attorney, we have cases, and you work with the cases, and you work with the children. Does it get tiring? I wouldn't say that. It doesn't get tiring. Our cases are very dynamic. They're not static. They're not cookie-cutter. Every child has a unique issue, circumstances, family background, and it's children's faith, and in this day and age, this is horrendous. And finding programs that they can, participate in. The program with the children who are driving cars without licenses. I've had clients who have taken that program and just walked away, right, and just in awe, making them realize that such breaking the law, what the consequences are, and our court, the juvenile court, is a rehabilitative court. A little bit punitive, but majority is rehabilitative. It's very important because these, they're children, and they come before the court. And our hope is to rehabilitate them, to make them good citizens.
The bar in Worcester that you work with here, what would they say about the past attorney work?
I have been very humbled by the feedback that I have had since this nomination. People see me as a fair person, a compassionate person, easily accessible. I can work as a mentor.
Do you believe if you look back in your records, you would recollect something different than Councilor Manning had alluded to or has brought up today in the discussion?
I usually have a very good memory, and it's not me. I don't have selective memory. I don't recall. I specifically recall Councilor Manning calling the office, asking for, there was I believe it might have been a guardian ad litem report that had been written, and asking that it be faxed to her office, which we did. I don't recall meeting her in court.
So when you would withdraw from a case, as she has requested, and you typically wouldn't, and I can understand why, but it's because she had somebody take over and she was a friend and so forth, would you make that motion in writing first to the court and bring it, drop it there, or would you mail it, or would you fax it?
You mail it. You mail it to the court.
Okay.
And you appear before the court.
So you mail it, and perhaps the day in question that was brought up, would you have been in court that day and went to resolve your relationship? Is that?
No. We file a motion, we mail it, we mark it up. Okay, you can't just walk something in the court. In the probate court, we have a one-judge system. Depending upon the last two numbers of the docket, it's then assigned to a judge. That judge has the case for the life of the case. So you would have to find when it was that judge's motion session. And then you mark it up, and you do a certificate of service. The certificate of service is that you give a notice to Mrs. A, and that it's going to be heard on a certain day. And then we go to court, and we go before the court, and we ask to what the court allows us to withdraw. And in this particular case, I'm positive that the motion would have said that I'm withdrawing because the client has retained successor counsel.
Was that successor counsel and that client have to leave when you did that?
No, the client is given notice
Prior to that.
prior to that. That's correct.
So if you were in court on a said day that was referenced by Councilor Manning today, it would have been to show up to respond to the motion that already filed to dissolve the relationship.
Yes.
Is that, do you recollect having done that?
I don't recollect it, and I'm sorry that I don't, but I don't recollect it.
But you would have gone, you did go to court one day to do that,
Yes.
correct?
Yes.
But it wasn't a day that you ever seen the client or Councilor Manning?
No. I don't recall talking to Councilor Manning. And all I recall is that she became successor counsel, that I had faxed over a report, and that I had gone to court and I had withdrawn.
So from a phone call with the client, you would not have needed to coordinate a meeting of the successor attorney and the client at court for any reason?
No. Once the client says, I would like you to withdraw from the case, you withdraw from the case, you file a motion, you withdraw from the case. And you don't ask. This client volunteered the information that Mary Ellen Manning was a friend of hers, and that she could not afford to pay counsel any longer, and that she was going to Mary Ellen Carolyn Manning was going to represent her. That was that, and as I said, I recall a phone call asking that we fax over a report, which we did.
I appreciate the witnesses. I look forward to hearing maybe more clarification myself, but I appreciate that. And as I said, I think you will now probably love the experience that you bring.
Thank you very much.
Councilman, do you have any more questions?
Well, for questions, thank you. For questions, I just wanted to ask you about the bankruptcy. You said that that client had gone bankrupt. So you got notice from the bankruptcy court that you were a creditor?
Yes.
Well, I did. I wasn't. I wasn't pointing on it. Yeah, I mean, I think, there's certainly some difference as to what the reason was for the withdrawal. You know, my memory of the situation isn't the same. Of course, the day of the incident, Attorney Capuano doesn't remember it at all, so my memory is the only memory that there is. My memory of the situation is that the withdrawal was the other way around. And Attorney Capuano moved to withdraw. The client was panicked about who she was going to be able to get it, for a successor counsel in the situation. But that's neither here nor there, really. The withdrawals of her, terminations of relationships with her. What I was concerned about as a colleague, and what I was concerned about as as somebody who has a professional relationship with his client, and prior to that, I was concerned with the fact that I had gone, to Worcester, which is quite a way from home. I think it took me almost 3 hours to get there. The highways were under construction at that time in and around Worcester, and 3 hours back. I went there with the client because the client wanted to be able to address the court. There was a motion to withdraw because there was a contentious divorce, and lawyers can't just withdraw in cases. They have to present to the court why they should withdraw. If there were successor counsel already on file, there wouldn't be any need to file a motion to withdraw. But the counsel was filed an appearance, and Attorney Capuano would have been able to leave. But that's been my experience. But we went there because we were informed there was a court date. So we went there and I tried to talk to Attorney Capuano, my client there. And she didn't have time to talk to me. She said she'd be right back. She went into the courtroom. We were waiting. When she came back out, I said, I really need to talk to you. And she said, I've already withdrawn. She just walked away from me. So that's my memory of what happened. Editorial comments aside, I'll say those for my vote. That's what I recall happened. And I did confirm I did call my former client to ask her if I had recalled it correctly. And she actually didn't have, she said I did. But I didn't specifically talk about the reason for withdrawal. Like I said, that was the focus where my conversation with her. And, she didn't have anything to say about the nomination other than just confirming the vote. So that's it.
Mr. Chair, can I ask something?
Compliment.
Did you ask your client any commentary on the nomination? What?
Yeah, I did. I said that she was up for an appointment. She had anything to say about her appointment. And she said, well, I just want to point out to you, don't you remember that day, blah, 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 blah. And I said, I do remember that. So that was her answer to my questions about Attorney Capuano's qualifications.
I don't think we're going off track here a little bit.
Mayor.
Yeah, so.
Mayor,
No, I think there's additional questions by any of the councilors. I think they should be directed. They would be directed directly to the nominee.
Thank you. Thank you. Sorry, having heard what you've heard, subsequent to my question and the other comments, do you have anything to add in terms of that particular day, the recollection, or the reason for the withdrawal?
the reason specifically was that this woman told me she could not afford the clinic, and that she was asking for me to withdraw, specifically stating that Mary Ellen Manning was a friend of hers who would be representing her. In our court, we filed a withdrawal, and subsequent counsel filed their appearance. That is what the procedure is. So it is, I'm listening to this, and I do not recall any of this. I'm not a confrontational person, and I'm not a rude person.
May I follow up on the question? When you filed the motion to withdraw, would you have indicated on that what the client had said?
You basically say, you basically ask leave of the court to withdraw, and you state, this is the client is asked to withdraw and is retaining successor counsel. I would never, as I said in my testimony, I have never withdrawn from a case. If my client had asked me, I would have done it. I have not said anything.
So you did not ask your client if you wanted to leave because they had not paid you?
Absolutely not. Absolutely not. And I believe Councilor Manning has confirmed that, we get involved in these cases, and if they tear the retainer and they are not able to replenish the retainer, it's costly. I never withdraw. I would rather, at that point, it does become pro bono. But in this particular case, we were in court at least once a week, and there were many, many issues. And
Thank you. I just wanted to say that it's just disconcerting to me to know that Councilor Manning traveled 3 hours. You don't forget that when you drive 3 hours with a woman in your car to go to court, and that she spoke with you and all of this, and she was told that it was a court, that she's supposed to be in court that day, and that's why she came. She had a purpose. And it just is disconcerting how anyone could, any lawyer who you just said how contentious this divorce case was, that you wouldn't remember the conclusion of it in that day, and not remembering meeting Councilor Manning or having her say coming to you and you rushing off, you have no memory of that. That's a lot of consideration for me. And now we talk about the clients who just recently asked her not to recall that, or are you being dismissed or any of that. So she asked about the nomination, and she volunteered, and they both have the recollection of traveling 6 hours back and forth, and you coming out, and you dismissed it, and they didn't know. And I'm telling you, I was so impressed meeting with you and all your background, but that is disconcerting to me. How can you sit on a bench if you can't remember a very important time of that case? And you're sitting here with Councilor Manning, you said, when you sat there, you said, it's good to see you again.
I think the nominee has answered that
All right,
question
thank you.
many times.
I don't want to be there.
Well, I think we ought to be that way. What's happening now is there seems to be a disagreement between Councilor Manning's version of the story and the nominee's version of the story. We've gone over it and over it and over it. I do not doubt the veracity of either one of them at this point. I think to make this a focal point of what the person has done in their career, one little issue like this, I think is taken a little too far.
decided to go into legal practice because I felt helpless. I had my children from 10 minutes to 8 until 2 o'clock, and then they left me, and there was nothing that I could do to help them. I could only help them academically, and I felt that it was a natural progression to go from being a school teacher to a lawyer, and specifically wanting to represent juveniles.
So, since that time, how long have you been practicing?
I've been practicing for 16 years.
We spent a lot of time, and I haven't, it's unfortunate that you and Council Manning don't see eye to eye on how that all occurred. I do have to say, though, that oftentimes when things happen, especially within the public eye, different versions end up coming around at the time memories start to fade. For somebody who wasn't there, we do not have a client sitting before us or somebody that we can question, I don't think it's fair to attach or to be able to get to the bottom of what's happening here. The comments that you've had with your client, which are privileged, that you will know, something that might be helpful, but we can't get into that. So based upon what you testified here today, and others eventually have testified as how we'll make that decision as far as your candidacy goes, your nomination. I want to finish